powerful man in France, he was sent to execution like the vilest and most contemptible of criminals, by adversaries who would not command a regiment. The inference is that the September massacres, which have ever since been stigmatized as the deepest stain upon the Revolution, were veritably due to the Royalists, who made with the Republicans an issue of self-preservation. For this was no common war. In Royalist eyes it was a servile revolt, and was to be treated as servile revolts during the Middle Ages had always been treated. Again and again, with all solemnity, the Royalists had declared that were they to return as conquerors, no stone of Paris should be left standing on another, and that the inhabitants should expire in the ashes of their homes, on the rack and the wheel. Though Danton had many and obvious weaknesses, he was a good lawyer, and Danton perceived that though he might not have been able to prevent the September massacres, and although they might have been, and probably were inevitable under the tension which prevailed, yet that any court, even a political court, would be better than Marat's mob. Some months later he explained his position to the Convention when it was considering the erection of the tribunal which finally sent Danton himself to the scaffold. Nothing is more difficult than to define a political crime, but if a simple citizen for any ordinary crime receives immediate punishment, if it is so difficult to reach a political crime, is it not necessary that extraordinary laws intimidate the rebels and reach the culpable? Here public safety requires strong remedies and terrible measures. I see no compromise between ordinary forms and a revolutionary tribunal. History attests this truth, and since members have dared in this Assembly to refer to those bloody days which every good citizen has lamented, I say that, if such a tribunal had then existed, the people who have been so often and so cruelly reproached for them would never have stained them with blood. I say, and I shall have the assent of all who have watched these movements, that no human power could have checked the outburst of the national vengeance. In this perversion of the courts lay, as I understand it, the foulest horror of the French Revolution. It was the effect of the rigidity of privilege, a rigidity which found its incarnation in the judiciary. The constitutional decisions of the parliaments under the old regime would alone have made their continuance impossible, but the worst evil was that, after the shell crumbled, the mind within the shell survived, and discredited the whole regular administration of justice. When the National Assembly came to examine grievances, it found protests against the judicial system from every corner of France, and it referred these petitions to a committee which reported in August 1789. Setting aside the centralization and consolidation of the system as being, for us, immaterial, the committee laid down four leading principles of reform. First, purchase of place should be abolished, and judicial office should be recognized as a public trust. Second, judges should be confined to applying and restrained from interpreting the law. That is to say, the judges should be forbidden to legislate. Third, the judges should be brought into harmony with public opinion by permitting the people to participate in their appointment. Fourth, the tendency toward rigor in criminal cases, which had become a scandal under the old regime, should be tempered by the introduction of the jury. Bergasse proposed that judicial appointments should be made by the executive from among three candidates selected by the provincial assemblies. After long and very remarkable debates, the plan was, in substance, adopted in May 1790. Except that the Assembly decided by a majority of 503 to 450 that the judges should be elected by the people for a term of 6 years, without executive interference. In the debate Casales represented the Conservatives, Mirabeau the Liberals. The vote was a test vote and shows how strong the Conservatives were in the Assembly up to the reorganization of the clergy in July 1790. And the electoral assemblies of the districts which selected the judges seem, on the whole, to have been rather more conservative than the Assembly. In the election not a sixth of those who were enfranchised voted for the delegates who, in turn, chose the judges, and these delegates were usually either eminent lawyers themselves, or wealthy merchants, or men of letters. The result was a bench not differing much from an old parliament, and equally incapable of understanding the convulsion about them. Installed early in 1791, not a year elapsed before these magistrates became as ill at ease as had been those whom they displaced, and in March, 1792, Jean de Bray formally demanded their recall, although their terms properly were to expire in 1796. During the summer of 1792 they sank into contempt, and, after the massacres, the Legislative Assembly, just before its dissolution, provided for a new constituency for the judicial elections. This they degraded so far that, out of 51 magistrates to be chosen in Paris, only 12 were professionally trained. Nor did the new courts inspire respect. After the 10th of August, one or two special tribunals were organized to try the Swiss Guard who surrendered in the palace, and other political offenders, but these proved to be so ineffective that Marat thrust them aside and substituted for them his gangs of murderers. No true and permanent political court was evolved before Danton had to deal with the treason of Dumouriez, nor was this tribunal perfected before Danton gave way to the Committee of Public Safety, when French revolutionary society became incandescent through universal attack from without and through insurrection within. Danton, though an orator and a lawyer, possibly even a statesman, was not competent to cope with an emergency which exacted from a minister administrative genius like that of Carnot. Danton's story may be briefly told. At once after Valmy the Convention established the Republic on January 21, 1793. Louis was beheaded, and between these two events a new movement had occurred. The revolutionists felt intuitively that if they remained shut up at home, with enemies without and traitors within, they would be lost. If the new ideas were sound, they would spread, and Valmy had proved to them that those ideas had already weakened the invading armies. Danton declared for the natural boundaries of France, the Rhine, the Alps, and the ocean, and the Convention on January 29, 1793, threw Dumouriez on Holland. This provoked war with England, and then north, south, and east the coalition was complete. It represented at least 500,000 fighting men. Danton, having no military knowledge or experience, fixed his hope on Dumouriez. To Danton, Dumouriez was the only man who could save France. On November 6, 1792, Dumouriez defeated the Austrians at Jemmapes. On the 14th he entered Brussels, and Belgium lay helpless before him. On the question of the treatment of Belgium, the schism began which ended with his desertion. Dumouriez was a conservative who plotted for a royal restoration under perhaps Louis Philippe. The Convention, on the contrary, determined to revolutionize Belgium, as France had been revolutionized, and to this end Cambon proposed to confiscate and sell church land and emit assignats. Danton visited Dumouriez to attempt to pacify him, but found him deeply exasperated. Had Danton been more sagacious he would have been suspicious. Unfortunately for him, he left Dumouriez in command. In February Dumouriez invaded Holland and was repulsed, and he then fell back to Brussels, not strong enough to march to Paris without support. It is true, but probably expecting to be strong enough as soon as the Vendéen insurrection came to a head. Doubtless he had relations with the rebels. At all events on March 10 the insurrection began with the massacre of Machecoul, and on March 12, 1793, Dumouriez wrote a letter to the Convention which was equivalent to a declaration of war. He then tried to corrupt his army, but failed, and on April 4, 1793, fled to the Austrians. Meanwhile La Vendée was in flames. To appreciate the situation one must read Carnot's account of the border during these weeks when he alone probably averted some grave disaster. For my purpose it suffices to say that the pressure was intense, and that this intense pressure brought forth the Revolutionary Tribunal, or the political court. On March 10, 1793, the Convention passed a decree constituting a court of 5 judges and a jury, to be elected by the Convention.